Music Podcasts.
Hi guys, welcome to Learn Kenyan Law with Wanjiku. I am your host, Wanjiku Mwangi. And as we've said, we've been continuing with the Civil Procedure Rules series. And again, we've been joined with Miss Aruka. Karibu sana, Miss Aruka.
Asante sana tena.
Yeah, thank you for taking us through this journey of understanding the civil procedure rules. Mm-hmm. And so for today, we're specifically talking about judgments and decrees. We want to understand every time you're going to court and, I have already written the plaint, I have amended it if I needed to amend it. We went into the court sessions and now the judge is supposed to give a judgment. So what is a judgment?
I can define a judgment as a statement given by the judge on the grounds of a decree or order.
Okay.
Yes.
So basically this is what a judge says. That is what we are saying.
Yes.
Uh-huh. And so when should I get a judgment?
It depends with the court, at court discretion.
Yes.
Some court give it immediately and some within 60 days. Yes, in an open court.
Yeah.
Judgment should be given in an open court with the presence of the advocates, both advocates, or even if the parties wants to attend, it is at their own discretion and it is allowed, is the court. And then the judgment.
Yeah. So basically you're saying that I should get a judgment either at once, immediately after the case is done, or rather within 60 days at least.
Yes.
Okay, and it should be in an open court.
Yes.
Okay, so what are the contents of a judgment? What should I expect to see under the contents?
The judgment should be dated and signed by the magistrate or the judge who is reading it.
Yeah.
And then the judgment must contain conscious statement, conscience statement of the facts of the case. Judgment should contain points for determination.
Okay, so we've said it needs to be dated and signed.
Yes.
It has to contain the statements of facts.
Yes.
And the next thing that you've said is that?
Contain points for determination.
Okay,
what
so
actually is the court, the issues to determine.
Okay,
Yes. And then judgment must also contain decisions on each of those points.
Okay, so basically you've said that it should contain the issues, and then that judgment should contain a decision of this specific issue. So like if we're having 4 issues, we need to have a decision of issue 1, issue 2, issue 3, issue 4.
Yes.
Okay.
And then judgment must contain reasons for each of those decisions.
Okay.
The magistrate or the judge should give reasons.
Yeah, for why they're deciding that issue the way they're deciding it.
Yes.
Okay.
And then judgments must show a judge applied their mind intelligently.
Yes, definitely,
Yes, and then judgment should have no irregularities. Yes. And then judgment should be clear. Should not be vague.
Oh, yes. I really understand what you mean. Okay, so you've said clearly that number 1, these judgments should be dated and signed. Number 2, they should contain the facts of the case. Number 3, they should be able to point out what are the issues of determination when it comes to this matter. If there are 4 issues, we list them down. And then the next thing, we need to get the decisions of each issue. And you've also talked about the fact that this judgment should not be vague, it should be very clear. And you've also said that it does not have to have irregularities. Okay, that is very interesting. And another question I have to ask is that under which order are we getting issues of judgments? It's under the civil procedure rules, right?
Yes.
It is under order?
We wanted to talk under Order 21 so that to get clear definitions of a judgment or even the decree.
Okay, sawa. Let's continue.
And then judgment must be made of points raised in the pleadings in the course of trials.
Okay.
And then judgment must record all points raised by the parties.
Okay.
Yes.
Okay.
And then also I can say that when the magistrate or the judge wants to write that judgment, he should consider both parties.
Yeah.
if it's in a civil case, both the parties, what the plaintiff or even anything that they brought before the court for the determination of their cases, the judge should not be biased on one side. He should look at both sides, parties and both their pleadings, so that to make the accurate and proper judgment.
Okay, that is really well understood. Basically, a judge is impartial.
Yes.
Yeah, we've really seen that our judiciary system has really worked so hard in ensuring that judges and magistrates are impartial. They are not having interests, and if they're having an interest in the case, they have an option of, saying that I cannot listen to this case because then I have an interest in this case, which shows us there's impartiality in judiciary. Okay,
And then judgment must be judicial in nature, meaning that the language used should be proper, should be dignified, and should be moderate.
Okay, so no matter which kind of offense I've done, even if I've killed someone, under the judgment should not be, rude, so to speak. A judge should not include in their judgment something that is rude or improper.
Yes.
Okay, so great. So are we done with judgments and are still under Order 21?
Yes.
That is really interesting. So if I can just do a recap, we've said that a judgment can be done at once or within 60 days. And we've also said that a judgment can be done, should be dated and should be signed. And again, we've also talked about the fact that a judgment should include things like the facts of the case. It should include things like the issues that are supposed to be, sorted out under the case. And it should also include the decision of those specific issue and the reason of that decision.
Yes.
So now we move on to the next thing, which is a decree. What is a decree?
What is a decree? A decree will normally do the summary of the judgment rendered by the court.
Yes.
Whatever the judgment, the outcome of the judgment, or what the judgment, how the judgment was read by this particular magistrate, and if there were damages or special damages, interest, cost of the suit that were awarded by the court in favor of the plaintiff or even in favor of the defendant, then the decree will contain those summary judgments, the summary of what was awarded by the court to the party.
Okay, so basically you're saying that a decree is like a final order of the court, and it's basically a summary of that judgment.
Yes.
Because sometimes the judgments are really long, and you sometimes you don't even want to read through them. But you're basically saying that a decree is like a technical translation of the judgment, which is also capable of being executed, so to speak. Okay. What else should we note about a decree?
A decree should also... since we know that it's the general outcome of the judgment, then now how the party proceed with this decree is at their discretion now. Okay. Do they need to execute the decree? Do they need to, give time to the other party so as to respond to the outcome of the judgment? The execution of the decree is now at the party's discretion. Okay. Yes.
Yeah, I understand what you mean. And thank you again for taking us through the decree. And I don't know if there's anything else you'd want us to add on the decree.
When it comes to judgment and decree and under Order 29
under Order 21. Yeah.
Under Order 21. Yes, it's about understanding the judgment. Yeah. And it is very important for the plaintiff to participate actively in their cases, and even the defendant to participate actively in their cases, because failure to participate, it will, one way or another, prejudice you when now the decree is being executed against you.
Exactly.
You should actively participate, and you should actively ask your advocates. If you don't understand the process of these cases, or even you don't understand anything in the judgment, your advocate has the right and obligation as your advocate to do what? to explain further and even to expand further for a client to understand.
Yes. Very interesting. And I really do agree, because if you don't understand the judgment, then a decree comes out, and then things as, execution starts taking place. For example, as we know, probably a decree can also give instructions to an auctioneer. So if as a plaintiff or as a defendant you were not, carefully involved in that process, it might be too late for you to now start saying, I did not know or I did not, And advocates are good people. If you don't understand, they take their time to explain what did the judge mean. They are patient, so to speak. So again, you've said that the decree is the final order of the court. You've said it is a summary of the courts. And you've also pointed out a very important issue. When it comes to costs, interest, you find them at the decree. And we've said it also gives the auctioneers instructions. So my question, or rather another focus that I would want us to talk about, is that who writes these decrees? For example, in the lower courts, who writes the decrees? And in the higher courts, who writes the decrees in practice?
When a judgment has been rendered, and you want now to do the summary of the judgment, that is the decree now, you can, where now the suit was in favor of the party, the party can apply for a decree. Write a letter to the chief, to the executive officer of the court, stating that you need or even want, and they should provide you with the decree herein that was made, and then they should, accompany you as the advocate, accompany it with the letter, and the draft decree. The draft decree. Stating what, but it is the registry now, or even the court, who will now rectify this decree at their court's rate. After rectifying and after having the better decree, then you shall take the decree and you shall do what? You shall serve the other party within 7 days, notifying them that a judgment was rendered, and here is the decree. Tell us the way forward before executing. You have to notify the other party that decree has been, we have obtained this decree, and we would wish that, you pay the sums as per the decree attached. Yes.
That is very interesting, and thank you again for sharing that information. So I really hope that our listeners have been able to understand what is the difference between a judgment and what is the difference between the decree. What's the difference between a judgment and a decree? And we have said that this is found under Order 21 of the Civil Procedure Rules. And in case you guys have any more questions, in case you'd want us to talk more about a specific thing, especially under the Civil Procedure Rules, under this series that we're having with Ms. Aruka, feel free to write a comment here below. Feel free to ask anything, request for anything. And if you've still not understood something, also inquire. Ms. Aruka, do you have a final, our parting shots?
Yes, I would say that one can always challenge the decree, and even one can always challenge the judgment based on the facts in the law. Yes, if you can challenge that, and if you want to challenge that, then well and good. Just do it at the specific time frame. That is, given. Yes.
So what I hear you saying actually is that a decree can also be used when you're applying for an appeal.
Yes.
Okay, sawa. I really appreciate you for coming here today. Thank you so much for also availing yourself for us to learn more from you. And guys, I hope you've also learned a lot from this session. If you have any questions, feel free to ask. And continue listening to us for you to learn more. If you're an advocate or a lawyer or a law student, I feel like this is a platform for you to learn more. And just for civic awareness, it's also important for you as the member of the public to understand when you hear an advocate saying a judgment, what does it mean? when you hear a decree, what is it? So until next time, see you. Bye.
Music Podcasts, the home of podcasts in Kenya.